For those that are on with us, welcome. We are asking everyone to please mute yourselves. We tend to have a problem with that. So again, please mute yourselves. Shannon and I will be speaking. Shannon Jenkins, attorney at Treadway, Lumsden and Doyle, and I'm Audrianne Adams Lee from HR Network. So we wanted to present an update today on paid sick leave. Most of you by now should have your paid sick leave policies and programs out. However, there was some emergency legislation that came out of the state of California in early July. So we want to talk about what some of those changes are and try to answer your questions. Not sure if we'll be able to answer everyone's questions today because we know that there are so many around this issue. But hopefully we can get those answered and then assist you with any of your own policies or programs that you're presenting in your at your company. So let's go through a couple of welcome, Shannon. I want to say hello to you as well.
Okay, thank you. Good morning, Audrianne.
Okay, so let's go through some of the changes. The first one was on modification of record keeping. So the Healthy Families Act, there's quite a long name to that, but it's essentially the Healthy Families Act, said that you had to maintain a record of hours worked and paid sick days accrued and used for the past 3 years. However, the amendment that just came on, that came out in early July, said that the employer is not obligated to inquire into or record the purposes for which the employee uses the paid leave or paid time off. So while you record the hours paid, worked and paid, you're not required to say for what purpose they were necessarily used. Okay, there was an expanded exemption for certain construction industry employees. So the Act provides an exemption for construction industry employees who are covered by a collective bargaining agreement that meets various requirements, and it defined construction employees as an employee rendering on-site work associated with construction. The AB 304, that was the amendment that came out in July, eliminated the word on-site as a requirement for somebody being in the construction industry, thereby expanding the exemption's applicability. So it's still for construction industry employees who are covered by a collective bargaining agreement, however. Okay, as a reminder, San Francisco and Oakland employers, they have different policies that differ from this paid sick leave policy. They're actually stricter and require more of you. So if you are an employer in San Francisco or the city of Oakland, or have employees working in the city of San Francisco or the city of Oakland, you need to know what the local ordinances are for those cities. Okay, and just one reminder again, please, if you are not muted, please mute yourself. Okay, sick leave grandfathered plans. So if you were an employer already providing paid sick leave or paid time off to a class of employees before January 1, 2015, as a reminder, the law went into effect in January 1, 2015. However, it was not effective till July 1st, 2015. So this provision covers employees hired into the class after that. The company continue with the existing sick leave plan. In other words, the plan you had prior to 2015, if it satisfies the Act's obligation of providing a pre-existing accrual on a regular basis, in other words, monthly, every pay period, etc. The employee got no less than 1 day or 8 hours of accrued sick leave or paid time off within 3 months of employment of each calendar year or in a 12-month period. The employee would accrue at least 3 days or 24 hours off within 9 months of employment. So in other words, if your sick leave plan prior to January 1, 2015 met the obligations of the Act, you don't really have to make any changes. Okay, so amounts and usage. Earnings of sick leave. An eligible employee earns 1 hour of sick leave for every 30 hours worked. And who is an eligible employee? Well, as a reminder, it's pretty much anybody. It's full-time, part-time, or even temporary employees, as long as they work 30 hours in a year. They get 1 hour of paid sick leave for every 30 hours worked, beginning July 1st, or the employee's first day of work, whichever is later. And for exempt employees, it's determined, the idea is that they work a 40-hour work week, regardless of what they actually work, just for the purposes of sick leave accrual. Employers can cap the sick leave. Employees can start, meaning, so several caps that you can put on there. One, you can say that employees may not use their accrued sick leave until they have completed 90 days of employment. And although the employees can earn 1 hour of sick leave for every 30 hours worked, you can limit their usage to 24 hours or 3 days per year. If you're on an accrual basis, the accrual basis requires that you allow a carryover, and the carryover is up to 6 days max. However, you can still require and have a rule that employees can only use 3 days a year. So even though you have to allow the carryover, you can cap usage at 3 days per year. Well, some employers have asked, why would I do that? I mean, that seems silly. If the cap is 6 days, why have a cap if I can limit usage to 3 days per year? And the idea of that is so that the employee is not necessarily without usage of any sick leave at any time. So when the rollover occurs into the new year, the employee would still have time, even though they might not have been on the accrual in the new year, to fully earn their 3 days. Okay, so as I said, your cap can be at 48 hours or 6 days per year. And of course, you can always do more. I mean, I have employers who offer more than that, and you can always do more. You just cannot do less. Okay, so as a reminder, you should put in your handbook or your policy what the sick leave increments would be for both exempt and non-exempt. However, they can't be more than 2 hours. So if you had increments, let's say for exempt or even non-exempt in the past of 4 hours or a half day or 8 hours or a full day, you can no longer use those increments. They have to be in 1 or 2 hour increments. I usually suggest 1 hour increments. It's much easier to understand and manage. But even if you use 2 hour increments, the idea behind that is you can replace time off in a day for each full amount of incremental time taken. So in other words, if an employee comes in and works 2 hours out of an 8 hour day, you would replace that with 6 hours of sick leave, or 3 2 hour increments, or 6 1 hour increments. In other words, each full amount that they are out of your incremental time is how much you would replace with their sick leave. Okay, so you have 3 options when it comes to accrual and carryover policies. And while employees can accrue sick leave during their introductory period, you can enforce that they can't use it till after they've completed that introductory period. And then they accrue sick leave of 1 hour for every 1 hour sick leave for every 30 hours worked. And your options are to accrue it that you provide them no less than 24 hours by the 120th day of employment, or in a 12-month period, or you advance them 3 days on the start of their employment, a calendar year, or any other 12-month period. And this is front loading, essentially. So if you front load, it relieves you of any carryover requirements. Or the third option. Employers provide 24 hours or 3 days of sick leave that's available to use by the 120th day of employment. And each year thereafter, the employee finishes his or first calendar year or 12 months employment, they get another 24 hours of paid sick leave. So that's also another way of front loading it. Okay, so again, maximum accrual, you have two options. The first option is if you accrue it over a period of time, then you have to roll it over. Unused sick leave at the end of the year rolls over to the following year up to a maximum of 6 days. Once this is reached, all further accruals will cease, and then they start up again once the employee has taken some time off and dropped it below the maximum. But remember, with this, even if they reach the maximum, even if they take some time off and they keep accruing again, you can cap their usage at no more than 3 days per year. Or for lump sum methods, in other words, if you front load, you can say unused sick leave does not roll over into the next calendar year, anniversary year, or whatever year you designated. Okay, so as a reminder about what the permitted use of sick leave is, if an employee needs sick leave, you need to allow it. Where in the past we said we may require a doctor's note, and if you don't provide a doctor's note, we can withhold sick pay. You can no longer do that. You also cannot ding an employee or take any kind of disciplinary action because they did not provide a doctor's note or they didn't call in by a specified period of time. The rule now is that we can ask them to provide reasonable advance notice as long as it's foreseeable or as soon as it's practicable. In other words, you know, if they said, well, I was getting ready to come to work and getting dressed and I was getting ready to get in the car and I just realized I just don't feel good enough to come in. And I know it's only 30 minutes before the start of my shift, so I'm supposed to call in at 60 minutes. You would have to accept that as soon as practicable or reasonable advance notice. The other thing is, you know, again, you can't exceed the 2-hour incremental use of paid sick leave. Okay, one of the big changes, which is a positive for employers, originally in the Act, it was written that you had to do a 90-day look back to determine average total wages divided by hours worked to come out with a new average hourly rate for that employee. And that 90-day look back encompassed things like commissions, piece rate, any non-discretionary bonuses, etc. So that was going to be quite challenging, not only to figure it out for the calculation, but for people who might pay out commissions or piece rates or bonuses. Very expensive potential proposition. The amendment now is giving you the option of continuing to pay that way, i.e. putting the 90-day look-back average hourly rate in place, or just paying at the employee's base pay at the time of absence. So in other words, if I make $10 an hour and I get commissions and piece rate of some sort, you can either pay me by looking back 90 days and adding up all monies earned, in other words, all my hourly rate plus all commissions earned, dividing that by hours worked to come up with a new average hourly rate of which you would pay me my sick leave, or you can simply just pay me at $10 an hour, my base rate of pay. I think for most employers, they're going to opt for the second option. And then as a reminder, sick pay is not used when you calculate overtime or any other special forms of compensation. So if I worked, let's say 35 hours in a week, none of which were overtime, and I also took 8 hours of sick leave, so my total hours, including the sick pay, was 43 hours in a week. None of that would necessarily be overtime. In other words, the sick pay doesn't get used for the calculation of overtime. Okay, we're hearing some background noise. Again, a simple reminder, please, if you are not muted, please mute yourself. We'll have an opportunity down the road for people to unmute and ask questions. Okay, so as a reminder on notification, so we talked about, this is what I've done is I've taken a section out of our handbook to kind of talk about what you can and can't ask for notification. And again, we ask employees that as soon as it's foreseeable, they provide notification that they would be out sick. We can tell employees it's their responsibility to personally call and speak to whomever you identify, typically the supervisor, in order to report their absence, unless, of course, it's an emergency situation. You can say voicemail is not acceptable. Now, as far as the doctor's note, the employee will be asked to provide the company with a note from their physician on the 4th consecutive day of absence due to illness. So in other words, we can ask for a doctor's note on day 1, day 2, and day 3. But if they don't provide it, we cannot take adverse action against the employee or withhold sick pay as a result. On the 4th day of absence, or after either 4 days in a row or after exhausting 3 days in a calendar year, we're no longer under the umbrella of the paid sick leave rules necessarily. So now we can go back to what we're kind of used to and saying, okay, you've exhausted your sick leave. We now will require any further absences to be to give us a doctor's note. Okay, I'm asking everyone, please mute yourself. We're having some really bad feedback here from somebody who's not muted. So please mute yourself. Thank you. After 3 days of consecutive illness, the company requires employees to provide a release from the doctor in order to make sure they're able to return to work, or if any modified work is needed, or the restrictions necessary for restricted duty. So remember, you always have a right to ask for a return to work note. In other words, to make sure that that person is able to come back safely and do the job with or without an accommodation, or to understand if there's any restrictions, and make sure that if you can accommodate those restrictions, and that the person's not going to come back and get everyone else sick at work. Okay, sick pay is not treated like vacation pay. The company does not have to pay out any sick leave upon termination of employment. However, there is a rule under the Act that says if the employee is rehired within 1 year, the company must reinstate whatever previously accrued and unused sick leave they had as of the date of separation. So while it's not a payout, if you rehire that employee within 12 months, you would have to reinstate whatever sick leave they had. Okay, notices to employees. You were required on or before the 1st of July to provide employees with a written notice on their, I'm going to go to the second one, then I'll come back to the first one. So Labor Code Section 2810.5 notice. This is a notice that came into play over a year ago for employers, non-exempt employees to identify, actually, and in this case it would be for all employees, to identify what their sick leave portion is, how the company is paying it. And there was a revised form that came out January 1, 2015 that updated the labor code form that included paid sick leave. And you as an employer need to check the box for what kind of paid sick leave you are providing in the box and have everyone sign off on that. If you aren't using Labor Code Section 2810.5, not just for this, but for any information on there that you are required to notify employees about, I would suggest that you call back and speak to either Shannon at Treadway or myself at HR Network, because we'll explain that to you. It's a lot more than just the paid sick leave. You're supposed to be using this at any time because it encompasses information about the company's address, DBAs, your workers' comp, and then how you pay that employee as far as their rate of pay and how often they're paid. Okay, so that's Labor Code Section 2810. Then also on the paycheck, you are required as part of their wage statement, their itemized wage statement, to provide them the amount of sick leave or PTO if you're doing PTO instead of sick leave, to let them know how much they have available to them. So you should have been working by now with your payroll company. All the payroll companies have been set up to properly track sick leave and set you up to identify that on each person's paycheck with what their accrual is, what they've used, and what they have remaining. Okay, there was a poster about paid sick leave under the California law that became effective January 1, 2015. So you should have that poster up with all your other legal posters. There is potentially a civil penalty for $100 for each offense. So if the labor board walks in and says, show me your poster area, and you don't have this poster up, it's potentially $100 for each offense. And I assume, I'm not sure, but Shannon, does each offense potentially mean each employee? Okay, I'm not sure. Shannon, are you with us? All right, we'll keep going. Okay, notice requirements. You're required to post the sick leave poster. It's called the Healthy Workplaces, Healthy Families Act of 2014, where it can be easily read. Now, and you can go straight to the California Labor Commissioner's website and download it there, and just, if you haven't already, print it. Also, we have it available if you, and we can email it to you. You have to remember to show how many days of paid sick leave each employee has available, either on their pay stub or a separate written document issued the same day as the paycheck. And you need to make sure you provide all the non-exempt hourly employees with their labor code notice, labor code section 2810.5 notice.
Audrianne,
Yes.
for your clients that are on PTO, will provide PTO, are you finding that the payroll companies that you're working with are breaking out the sick leave separately from the PTO on the pay? I
would say that I do not think they are, and is that required or is that suggested?
That is suggested, just so
okay.
people can understand what, because that's how you track how much of your sick leave is utilized. And I think it's suggested to break it out, but I'm not sure how practicable that is. We may want to have your payroll company speak to that at our new laws seminar that we have coming up.
Okay, that sounds like a great idea. All right, so that's kind of an overview of the changes that occurred. As I said, we have gotten many, many questions in our office for that. We also, and we've been helping our own clients with their policies and their handbooks. We kind of want to open it up now to questions that you may have. So, because I know there's been a lot out there. So let's open it up. Any questions anyone has? This would be a time to unmute yourself if you have a question and go ahead and ask your question. You can also type it in the chat box.
Hi, Audrianne. Okay, I have a question regarding to the 90 days of employment.
Okay.
So if we do a front load instead of accrue, does that 90 days still apply?
Actually, under the changes to the law, you can now do 100. If you front load, you can actually provide the 3 days paid sick leave at the 120th day of employment. Let's go back to that real quick.
Okay.
So let me find that. Because you had 3 options. Okay. So your three options were to provide, and thank you for that question. That's a great question, Kevin. If you don't mind now, I'm going to ask you to mute yourself and then see if I answer your question. So you can accrue it on an annual basis, provided they have no less than 24 hours by the 120th day of employment. You can accrue it over a 12-month period, and provided that and you can say that we will, the second method, your advanced 3 days or 24 hours, that's advancing somebody the 3 days right up front, but you can say they can't use it till they've been there for 90 days, okay? The other option is you can provide 24 hours or 3 days of paid sick leave that they can use on their 120th day of employment. So instead of accruing over a period of time, you can also front load, and in the first year they have to wait till their 120th days of employment, as long as there's 24 hours or 3 days in their account on that 120th day to use. So you kind of have three options. Again, front loading 3 days at the front, but saying you can't use it till after your 90 days. Front loading 24 hours or 3 days that they can use on their 120th day, or accruing and saying you can't use till after 90 days as well.
Okay, great. Thank you.
Anyone else? Any other questions?
Audrianne, are you finding some employees or some employers are using one policy more than the other?
Okay, that sounds like, was that Becca?
Yes.
Hi, Becca. That's Becca from our team. I would say I have not found it one more than the other. I think it's a real mixed bag of accrual versus front load. I think the challenge for some employers is the tracking and how much they want to track. It's certainly more administratively challenging to track the accrual and do the carryover than it is the front load. The pros and cons, what are the pros and cons? Well, the pros and cons are that somebody has sick leave in December and uses all 3 days, and and then you front load on January 1, they have 3 days available again, they use another 3 days. Could they end up being sick 6 days in a 2-month time period? They could. It's not something you have to worry about that because there's no payout upon term, so that's not an issue. So some people are just more comfortable with the accrual over a period of time, and employees can use it as they earn it. Any other questions?
Hi, Adrianne. This is Yusra. I do have two questions. The first one is, we have PTO accrual, and according to the law, it said prior to July 2015 and after July 2015. For after July 2015, they have to have the 3 days, whichever is the sick. But at the same time, it said that also on employee pay stub, it has to be, the sick is separately has to be shown. So in this case, the company who had PTO accrual with the sick and vacation, we have to separate those entry in the payroll, on the payroll. Did you understand what I'm saying?
Yes, I think I understand. So you have PTO,
Okay.
and we didn't really get into PTO today. Again, if you had or have a PTO program, as long as it met the requirements of the Healthy Families Act, the paid sick leave, then you didn't have to necessarily change your PTO program. But however, it did require that you, even if you use PTO, that you provide it on the paycheck. So if you weren't providing it before, you need to now. And just as Shannon was saying earlier, it's not required that you separate those 3 days out of your PTO to be designated for sick on the paycheck. It's only a suggestion. You just want to make sure that if you have a PTO program, you meet all the requirements of paid sick leave. In other words, your PTO would have to say 3 of these days of your PTO are available for all the same reasons that you could use the paid sick leave, and that you accrue it, and that you make sure that they earn at least 1 hour for every 30 hours worked, and that you either are front loading or accruing. Most PTO is always accrued, so it has to have the same rollover requirements, etc. And, you know, of course, the difference between PTO and the paid sick leave is PTO is treated as vacation. So anything left at the end of termination would have to be paid out. Does that answer your question?
You know, the law said on the employee stub, pay stub, it should show the 3 sick, the sick separately. So in this case, since we do have with vacation, the general term we call it PTO, so it doesn't show to the employee pay stub as a sick.
Okay, so what's really important in what you just said is words and semantics can play a big role when it comes to HR. So either you have a PTO program or you have a sick and vacation program. Sick and vacation would be separate, and each have separate rules that have to be applied. PTO is considered a vacation program, although within the rules of using and collecting PTO time, you can use it for sick. So what's interesting is if you have a PTO program, you kind of have to apply both the paid sick leave and vacation rules, even though by labor standards, it's considered a vacation program. So the things like paying it out upon termination apply. Shannon, anything you want to say about that?
I think what she's saying, if I'm hearing correctly, is that she has a vacation benefit as well as a separate sick leave benefit. And at a minimum, in that case, the separate sick leave benefit should be broken out and placed on the face of the paycheck stub. When you are in a PTO program, it's not necessary to separately break out the sick leave, but it is recommended or suggested, especially if you're not going to be paying a portion of that out on separation. In other words, you're separately designating those 3 days. For ordinary PTO, though, you don't. You pay everything out upon separation. So there would be no need to separately track it or account for it. So yeah, under the program that she's describing, which is vacation and sick, they should both be separately broken out on the face of the paycheck stub.
Thank you. Anyone else? Any other questions?
Sorry, I have a question regarding the employees being rehired within the year. A lot of times we have students that come back every summer and they work right around that 90-day period. Now that if it carries over the following year, when they start and rehire, do they still have to wait the 90 days, or do I have to allow them to have the sick leave right away?
Interesting question. I'm not sure we've had that one asked before. Do you know the answer to that, Shannon?
Restate that question again.
She's asking if somebody's rehired, so they have students who are employees, but they're rehired, and they have carryover in the year. They leave and then come back within the 12 months. So their sick leave is reinstated, but can they reapply the 90 days of introductory period when they come back.
Are they actually off the payroll?
That is correct, because they go back to school, so I don't pay them anymore. They just work in the summer.
I think in that case, because Audrianne and I have gone back and forth recently on this 90-day introductory period and when it applies to current employees and when it doesn't. If they're current employees with no break in service, I would say that if they're rehired within 12 months, even if they're off the active payroll, that accrual gets reinstated. I think the more conservative path is to waive that 90-day continuous employment period. I think you can make an argument that there has been a break in service, and although the accrual is immediately available, the usage shouldn't be permitted for another 90 days. But if they've already worked 90 days within that 12-month period, I think that would be a hard argument to make. I think your more conservative approach, which would be the more employee-friendly approach, would be to, for employees who are rehired within 12 months, who have already worked the 90 days, even though there's been a break in service, to allow them to immediately begin using that benefit.
An interesting question. It's actually not one that that's been posed before, and I will tell you, both Shannon and I have read this paid sick leave law back and front several times. Even have sent some questions to the DLSE for clarification. That is not specifically written out in the law. So as I always tell our clients, always best to take the most conservative approach until we get clarification. And how do we often get clarification? Someone else gets sued and they become the test case. And we never want to see any of our clients be the test case. Okay, any other questions before we wrap up? Okay, so I just want to finish up here and let you know that we do have some more webinars and hotspots planned between now and the end of the year. We already you can mark your calendars for, I believe it's January 20th. Is that date correct, Shannon? January 20th, we're going to be having our annual new workplace rules and laws for 2016. I can't believe we're even talking about that already, but so
it's January 21. January 21, Audrianne.
Okay, January 21. And there'll be more coming out about this. But along the way, if there's any more changes to the paid sick leave law, if anything, if any pressing issues come up or any significant cases between now and then, we will definitely throw together a hotspot to keep our clients and friends of both Treadway and HR Network informed. Okay, I want to thank everyone for attending. If you have any more questions, please feel free to contact Shannon directly or myself directly, and we'll talk to everyone soon. Have a good day.